Hello to our viewers. I'm very excited to be joining you today. I'm Aisha Ghani, Head of Office, Legal Aid South Africa, Germiston Local Office. We are in the midst of the 16 days of activism for No Violence Against Women and Children campaign. And this is the second of 4 Facebook Live broadcasts during this campaign, focusing on a number of important legal topics. Today we are discussing divorce, as well as protecting the rights of women and children in a divorce type of litigation. You are welcome to leave your comments and questions about today's discussion below. If we cannot respond to you today, during this video, please look out for a message from us or a response in our future video. If you require legal advice, you are welcome to call our toll-free advice line. I will give you the number. It's 0800 110 110, weekdays between 7 a.m. and 7 p.m. If you cannot call, you can send a please call me on 079 835 7179, and we will definitely call you back. Please like and share this video to spread the word on your rights. Going now straight to divorce litigation, which is a topic that affects families, not just individuals. I'm going to try and speak to you regarding all the contentious issues that come up in a divorce. So what happens on divorce? So the divorce attorney will always encourage the couples to come to an agreement with regards to contact and care in respect of children, property disputes, how to divide assets and liabilities, and then of course aspects with regards to maintenance. Now, I want to show you this book, which is the Children's Act. This is the new piece of legislation which was promulgated in 2005, which made a tremendous focus shift change towards children. So we no longer talk about custody and access like we did in the past. We talk about contact and care, shifting our focus now to children. So the Children's Act, as well as the Divorce Act, when it comes to a child, talks about where will the child live, how will the couple look after the child together in the form of an ongoing partnership post-divorce, what will be the needs of the child, and how will the parties look after that child, taking into consideration their own financial needs and affordability. And of course, last but not least, how will the child's social, economic, religious, and cultural needs be taken care of? It's not always possible to come to an agreement, so we recommend that agreements and roundtables commence, or rather, let's say that roundtable meetings commence as early as possible in the divorce. If you cannot agree to everything, you can and must jot down all the agreements in what we call a parenting plan. The parenting plan will then narrow down the issues that are still remaining in dispute. So what do couples do with those disputes? Where do they go for this? They approach either a mediator, which is a very feasible option because this keeps the parties in a cordial relationship post the divorce. And if the mediator cannot settle those, then we approach, of course, a court. Now, if when you draw up a parenting plan, it is highly recommended that it is in simple terms and for understanding of the parties. So in the event of a dispute post-divorce, this can be mediated further, or a court can be approached again. Now, there are different types of matrimonial regimes. And the matrimonial regimes that one can enter into upon marriage are the same regimes that will be used to dissolve the marriage. So the most common in South Africa are your in-community of property marriages, which I will explain to you as follows. For example, if Joe and Jane get married in community of property, Joe and Jane will share all the assets and the liabilities during the marriage and after the dissolution of the marriage. If parties get married by anti-nuptial contract, of course, they have an option. They can get married with accrual or without accrual. Now, the without accrual marriage is a complete marriage out of community of property with no sharing of the assets or the liabilities whatsoever. In most instances, donations, legacies, bequests made to the parties are excluded. If the marriage is with accrual, then upon dissolution of the marriage, as at the date of dissolution, the parties have to accrue or receive accrued benefits from each other's estates. So it's two different estates, separate estates, and the accrual amount is then calculated by looking at the growth of each estate. The bigger estate will obviously have to pay out the smaller estate, only the accrued amount. We can't forget about our customary marriages, which are also recognized by our Black Customary Marriages Act, as well as the Children's Act and the regulations. So parties do get married by Black Customary Marriage Union, as well as the Islamic marriages, or what we call the Sharia marriages, and the Hindu rights marriages. All these marriages are recognized on proviso that they are registered as customary marriages with the Department of Home Affairs. Once the marriage is registered with the Department of Home Affairs, parties do not need to fear. You can then again get to the table and settle the disputes. And failing such settlement or negotiation to settle, parties can then institute divorce proceedings in the normal route, of course. So when we come to the Children's Act, which I've displayed to the viewers before, this is really a very significant piece of legislation that encompasses a 360-degree approach to looking after and protecting the rights of children. The Children's Act introduced a departure from the traditional method of dealing with children's rights to using a more friendly approach, and with shifting the focus from the parties to the child. The child, firstly, what they did is they changed terminology. The Children's Act changed terminology from your traditional terminology of custody and access to contact and care. Now, what does the Children's Act, what does Section 21 say about people that are married by customary marriage? So it's not a complete lost case. If a father has lived with the mother in what we call a permanent partnership, and even if he hasn't lived with the mother, but he acknowledges that he is the father of the child. And thirdly, he consents to being identified as the child's father. And he contributes to the child's well-being socially, economically, religiously, and culturally. Then the partnership is a universal partnership and can be litigated from. Of course, again, depending on whether the parties have registered the customary marriage at the Department of Home Affairs. We're going to move on now to a bit of explanation and understanding for the viewers on what can parties do if they need interim relief. So let's take an example of Joe and Jane that were married for 15 years and tried to go to a legal aid lawyer to try and settle all their disputes. However, they settled everything with regards to contact and care about their 2 minor children, but they can't reach agreement on maintenance. Now, Jane is very concerned about this because from the 2 minor children, the one is a university student and the second child is in matric. Jane also has a further problem, and she cannot afford to continue paying the university as she is a stay-home mum and has been a housewife for 15 years. So what does Jane do? Does she wait for the divorce final order to be made by a judge or a magistrate before she pays for the university fees? And of course she can't practically do this. Jane has the right to approach a court to seek interim relief. So whilst the divorce is still pending, Jane can ask for maintenance, what we call pendete lite, pending the full litigation. So Jane will bring either a Rule 43 application in the High Court or a Rule 34 or Section 34 application in the lower court, or what we call the civil regional courts. As judges and magistrates are the upper guardian of all minor children, and they are there to look after the best interest of the children. No child should go without education, and no child should be deprived of leaving his goal and dreams just because of financial issues. This kind of litigation will be in place until the divorce is finalized. Once the divorce is finalized, or at the final hearing of the divorce, the judge or the magistrate will make a ruling on ongoing maintenance until the child reaches majority age or becomes self-sufficient. These type of applications are very expensive in the high courts, and therefore viewers are recommended to use the civil regional courts, which are in every local court's jurisdiction. If we move on now to a question that was posed by a viewer before the commencement of this briefing session. The viewer is married by black customary marriage, has 2 children, is unemployed, and her husband is a police officer with the South African Police Services. They share a joint property on which is also the common home where the parties reside with their children. And from my understanding of what she said was that the parties are co-owners on the title deed. The caller was concerned about what happens to the property and can her husband sell the property during this divorce. So my advice just briefly is as follows. Firstly, ensure that your customary marriage is registered with the Department of Home Affairs before any litigation can commence. Secondly, let chat with your husband so that he can get to an attorney, whether it be a private attorney or a legal aid SA attorney, so that the parties can try and settle, as I've explained, the settlement negotiation process already in great detail. Failing which, of course, a court needs to be approached, and either yourself, the writer who wrote to us, or her husband can start divorce proceedings. Divorce proceedings are started by the issuing of a summons on the other party, and this summons must be filed in court, or we call it issuing in court, where a case number is allocated to the matter. The plaintiff is the person starting the case, and the defendant is the person receiving the papers from court. The person that serves the papers on the defendant is the sheriff of the court, who will then take the process to the defendant's work address or residential address and explain the process to the defendant. The return of service is a document which is proof of such service. This then kicks off the divorce litigation process. I'm sure that viewers are also need to know the duration of a divorce. So the timelines can vary. In the event of an opposed divorce, it can vary from a year to 3, 4, 5 years, depending on what the contention issues are and how willing the parties are to be frank, honest in their negotiations and settle the dispute. It also depends on people's personalities, and certain personalities that do not want to lose. So my message again is that divorces are not about win and lose, but they're more about settling the issues as fast as possible to cause minimal damage to the ongoing relationships that fathers have with children and mothers have with children. And in terms of unopposed divorces, these can be quite quick. In the event of there being absolutely very little to discuss in an unopposed divorce, where there are no children, no property to divide, it can be 1 to 3 months. If there's property to divide or property which is in dispute, and if there are children and maintenance, contact and care rights and responsibilities of parents, it can be 6 months to a year or even to 2 years. This is the very reason why I propose that, irrespective of the nature of the dispute and irrespective of the duration of the marriage, that parties should in fact start off or kick off the process through negotiation towards settlement. What's always at the back of my mind is that this was a family, and when the couple decide or come to an agreement that they cannot live with each other, the family bond of sharing with the children, whether one party shares a father-son or father-daughter relationship with his child, and the mother shares an equal relationship with her children, that relationship, in terms of our basic human rights legislation, what the constitutional mandate is, should not be affected, should not be negatively affected, and should not be trampled upon. On a more social and cultural point, we want to promote adults that will be able to fit into the workplace, fit into social relationships, fit into ongoing healthy relationships in their lives. And if we're going to dissolve our own marriages in an unhealthy manner, what we do is damage. And this kind of social damage lives on in those children for a long time. And in order to erase that kind of damage, there's a strain financially and emotionally. Financially, because then you've got to get life coaches, psychologists, social workers involved to undo the damage. And in terms of economical strain, one or the other party is going to have to pay for this kind of a service that a social worker or a psychologist will render. So it's not a win-win for anybody. In fact, it's a lose-lose. So delaying these kind of matters that involve children and involve human beings is not recommended, not in terms of the Children's Act, not in terms of the Divorce Act and legislation, and of course not in terms of our Bill of Rights.
We have another question from Bronwyn. She says she relocated. Her children live with her ex. They have an affidavit stating that when she is settled, they would relook at the situation for the children to come and live with her. And now he hasn't agreed. She cannot afford lawyers. How can she go about getting her children? They have 50-50 and he will not agree to mediate or any mediation process.
So, yeah, this is this is what I was talking about earlier when I said not being amenable to mediation, not being amenable to going back to the drawing board to settle whatever disputes there are with regards to children is in fact a lose-lose situation, not only for the children but also for the parties. In the event of the father not wanting to go back to the mediation or back to the drawing board, my suggestion is that if there's a written agreement or what we call a settlement agreement, that a breach of that settlement agreement be invoked, and that the writer or the viewer that's just posted that on our Facebook page start proceedings for contempt of court. That's, of course, if the settlement agreement was made an order of court. If there was no order of court, of course, then the rights to approach a court for a court to make a decision in the best interest of the minor children is now the only option, as the one party has made it very clear that he does not intend to settle this amicably. The cost of this can outweigh the benefit if one looks at what benefit there is in a round table and a mediation. So my suggestion is still for her to approach him once again, explain the benefits of a settlement. If he still stands by his initial decision not to want to talk, not to want to negotiate, not to want to mediate, then the only option now then is to approach a court. I would just like to say you can leave your comments and questions about today's discussion below. If we cannot respond today to your questions or your comments during this video, look out for a message from us or a response in our future video. If you require legal advice, you can call our toll-free advice line on 0800 110 110, weekdays between 7 a.m. and 7 p.m. Or you can send us a please call me on the number I've mentioned before, 079 835 7179. and we will call you back. Please don't forget to like and share our video to spread the word on your rights. Thank you again for joining us. If you have any further questions, please use the options I've mentioned. Join us again on Wednesday morning at 11 a.m. for our third 16-day activism Facebook Live broadcast. We will be discussing domestic violence and different types of abuse, as well as protection orders. Send us your questions, and remember again to like and share our video and spread the word on your rights. Thank you and goodbye.